Just give it another minute. Okay, I think we can start. Well, welcome everyone to a very special seminar and the final seminar for the year. And we're really delighted today to host a book discussion of a book by Professor Kalpana Kannabiran and Devi Jagani, which is called Gendered Bodies and Worlds of Labor, Re-Conceptualizing Dignity After Puttaswamy versus Union of India. And of course, Professor Kannabiran needs no introduction. She's a very prominent social legal scholar and feminist legal scholar who has many books to her credit. And she's currently a distinguished professor at the Council for Social Development in New Delhi. And her co-author has also developing a line of work and books. And Devi is an independent legal researcher and lawyer. And in addition to our authors today, we have two readers of the book. We have Harini Raghupathy, who is part of our project on laws of social reproduction, and she's a lawyer, and she's litigated with the Human Rights Law Network in the past. And we also have Divya Ravindranath, who is at the Indian Institute for Human Settlements in Bangalore. And we're really delighted to have both a lawyer and a social scientist reflect on Kalpana and Devi's book today. So the format is fairly informal. We start off with a presentation of this wonderful book for about 20 to 25 minutes, and then we'll have our readers speak about the book for about 10 to 12 minutes, and then it'll be open for discussion. So thank you and welcome, Kalpana and Devi.
Thank you, Prabha. I'd like to begin on Devi's behalf and mine to thank you for this invitation, and also thank Divya and Harini for their willingness to read this and comment, because we haven't so far, I think, after we published the book, actually heard any substantive comments on it. So this is really, for us, a really valuable session. So thank you very much, Prabha, for this. I will, the way we will go about this is that I will just give a broad brush overview of this very small monograph, and in about 10 to 12 minutes, followed by Devi's longer reflection on some of the cases that and some of the points of law that we have tried to reflect on in the course of this work. Very broadly, to begin with, I would like to start off with where we started working on this, because I think that that is kind of important to understanding the scope of this work. It started as a 5,000 word book chapter in a book on laboring women or women in labor. And we just realized as we were reflecting on it, and that was supposed to be part of a much larger project on women in labor. And as Devi and I started to discuss what was to be a 5,000 word essay, we realized that there were just too many things that needed further discussion, and in a sense, a 5,000-word essay didn't give us the space to open out all the concerns that we thought needed to be opened out, to take a fresh look at the question of gender and labor, not just women, but gender and labor. We also felt that looking at women and labor kind of got the entire discussion stuck within a gender binary framework, which we were struggling with and trying also to break free from. And so what we ended with was a 35,000 word essay that was neither a book nor a book chapter. And well, that is what it is. But what did we try to do? Our, our task had several pieces to it. Devi, I'm glad we have a social scientist and a lawyer commenting on this, because even between us, I'm primarily a sociologist. My primary discipline is sociology. Devi is a lawyer and a legal scholar. And we tried to pool our understanding together to see what the scope of this book might be. And we came to a point where we realized that there was too much that was left unaddressed in the entire discussion on labor rights, gender and labor rights, not just gender and labor and gender and work, but gender and labor rights in relation to law, in relation to regulation, and so on. The first piece of this was a piece that I had earlier opened up with Shweta on the question of the need to draw an intellectual history of the debate on privacy in Indian law. And I think in Puttaswamy and the reflections of legal scholars on Puttaswamy, what had completely got left outside the reckoning was the long-standing feminist debate on the relationship between the private and the public, and the quantification and regulation of labor that that blurs these boundaries and follows women from the private to the public, and the whole debate on unpaid work, on housework, on the relationship between domestic work and housework, and care work. I mean, so there was a long debate that went back to the earliest phases of the Wages for Housework campaign in the 1970s, that simply did not inform the debates on Puttaswamy. And we found that that is a debate that is actually material to examining the question of gender and labor. So we're talking about feminist debates in different parts of the world that reflected on reproductive labor and the relationship between the public and the private, and how that might be understood within a dignitarian framework that Puttaswamy kind of enables. The second part of what we wanted to look at was the ways in which labor law itself seems to be understood more in terms of the boundaries of each statute, autonomous of everything else, where fundamental constitutional precepts and frameworks don't really inform an articulation, a more holistic articulation of labor rights. And so we felt that we need to look at labor and labor rights in a more expansive manner. The third part of it was that we, in trying to grapple with the question of gender and labor, we came across several bodies of scholarship: labor studies, gender studies, labor law, women's studies, constitutional law, and criminal law. And not to speak of Article 17 protections against untouchability and the annihilation of caste. So we had before us a vast expanse that we wanted to harness in proposing that a way forward to looking at questions of gender and labor regimes. And the way in which we decided to do this was by looking at different pieces of it, because we were very mindful of the fact that we were not here attempting to write a full-fledged book on the question of gender and labor. Our attempt was far more limited. We were trying to simply signpost the areas that need to be connected in order to arrive at a more holistic interpretation. So if you look at the chapterization of the book, you will see that it kind of begins, with broader questions, and then goes on to looking at specific questions in the law, ending, beginning with the whole question of labor and the dichotomy between the private and the public and the question of transgressions, and ending with how we might actually understand the proportionality standard in relation to questions of gender and labor. Uh, there are, of course, other departures that we make in being mindful of the fact that we are not talking merely of women workers. We try to see how we might address questions of trans workers, queer workers, and cis women workers as important to an understanding of the subordination of people within gender regimes. And of course, the description gets to be quite a mouthful, but then the area of gender is itself messy and is not neat and watertight, and that messiness, I feel, is also reflected in our insistence in describing the area as, cis women, trans, queer workers at every point, because you need to be very conscious. We needed to be very conscious of the fact that we are, in fact, looking at that entire at gender plurality in order to understand what we were trying to say. But of course, we hit a limitation there, which was that in the literature we are talking, we are constantly confronted by binaries. We are confronted by cases to do with women, marital rape exception where it concerns women, domestic violence where it concerns women. So the case law that we are drawing on is again fairly stuck within a binary. So our effort was to say, how do we look at cases that are stuck within a binary in ways that might reflect ways forward for a gender plural labourscape? So in this, Devi and I had earlier worked on the question of disability and employment, disability and labor, disability and dignity. And we tried to bring our experiences of that space to bear on what we were dealing with in the materials before us. I won't go into specific cases, but I would like to read a short excerpt from the conclusion, which I took from Megha Sharma's, lovely PhD thesis on the juridicalization of labor in post-independence India. And I think that this passage actually immediately spins into view the need for us to rethink the gender terms in which we understand labor. And I quote, This is from the chairman, the Central Board of Workers' Education, 1981. Labor should do the housekeeping for the nation. Labor is like the housewife who cooks for the entire family, but does not sit first to the meal just because she has sweated and cooked. She feeds all the members of the family first and takes her turn last. Labor too should serve the community first. Unquote. So, in an official document, we have in a sense, the queering of the labor pitch, where the question of labor itself is likened to women's labor within the family. And I think, that in a sense goes back to what we were trying to do, which is how do we open this up to a more nuanced and a more complex understanding of what we need to look at and the ways in which we need to look at labor. Yeah. So I'll stop here, Devi.
Thank you, Kalpana ma'am, for such a enlightening recapitulation of the scope of our book and the vision with which we tried to write it, and outlining importantly matters that are beyond the scope of domain of our essay, and for drawing on its implications for the feminist and legal understandings of gendered laboring bodies. In my presentation today, I will be more specific and pick out on a select few arguments that are advanced in our monograph and highlight the novel ways in which they attempt to rupture the settled notions on gendered laboring bodies. In this monograph, as already recapitulated by Kalpana ma'am, we ambitiously strive to present a contextual, conceptual, and a gendered reading of the 9-judge bench decision of the Supreme Court in the case of Justice K.S. Puttaswamy and the constellation of cases around it, such as Navdeep Singh Johar. And thereby, we want to advance a critical constitutional approach for understanding the situation and the precarity of cis women, trans, and queer workers. And we want to more broadly articulate a conceptual base on which these workers and the courts may build their claims and their reasonings for more just, fair, humane, and dignified working environments. Through our review of the existing scholarly literature across the fields of labor studies, gender studies, sociology, law, we have tried to demonstrate the central fact that the opportunities available to cis women, trans, and queer workers are curtailed by the operation of the norms of heterosexual patriarchy. These norms, they not only penetrate the socio-political and economic lives of women, so to say, but they also insidiously penetrate the juridical sphere. And while on the face of it, judicial reasoning seems to be located within constitutional or statutory dicta, it is in fact advancing the norms of public morality. And nowhere is this more clearly demonstrated than in the invisibilization and undervaluation of women's unpaid domestic and care labor within the home. We understand the issues raised by the devaluation of women's unpaid domestic labor, not only from the perspective of the public-private divide, but by trying to emphasize its inherent connection with practices of domestic violence and the operation of the marital rape exception. This is what we refer to as the domestic work, domestic violence, and marital rape triad in our book. In India, the courts have deliberated on the value of housework and unpaid domestic care labor of housewives in the context of calculating the compensation that should be awarded to the housewife or her dependents in the event of her disability or death, respectively. In this context, in our essay, we have tried to analyze the decisions rendered in the case of Kirti, Sarang Divakar Amle, and Kalu Kutti. And from our analysis of these judicial decisions, we can find or we can identify two main shortcomings in the way in which they evaluate the worth of unpaid housework performed by wives within the confines of the home. Firstly, they only seek to reflect upon the worth of a wife's unpaid domestic labor in the face of exceptional hardship, that is, injury, disability, or death. And they are not trying to evaluate and value this work as a matter of routine existential deliberation. Now, this only serves to signify the extent to which courts, even today, invisibilize and normalize the asymmetric assumption of responsibility for and the dignitarian harms associated with the performance of unpaid domestic and care labor. Secondly, although on the face of it, these cases seem to advance the cause of gender justice by awarding adequate compensation so as to further the constitutional ideals of social equality and dignity, they fail to recognize and to thereby dislodge the forced assumption of responsibility for housework. And this only reflects how judges advance their patriarchal ideologies in indirect, intractable ways. This is most clearly demonstrated in the case of Kirti, when the Supreme Court of India says that women's responsibility of care work, whether by choice or as a result of socio-cultural norms, is to be evaluated in the same way. This whether or dichotomy, it importantly separates and distinguishes the experience of consensual intimacy within a marriage from that of rape experientially. Yet, the conflation of this dichotomy is expressed in its most chilling fashion through the marital rape exception in Indian criminal law. The insidious ways in which reductionist judicial reasoning can rob the potential of the right to privacy, which includes sexual decisional autonomy, to advance the cause of gender justice, is exemplified when we look at Justice Hari Shankar's judgment in the case of RIT Foundation. Justice Shankar upholds the constitutionality of the marital rape exception based on the argument that there is an intelligible differential between non-consensual sexual intercourse by a stranger and non-consensual sexual intercourse by a husband. He says that the stranger is a violator without a right, who therefore violates and disrespects the woman's right to independent sexual choice, particularly her choice as to her sexual partner. On the contrary, the husband is seen to have a right to expect meaningful sexual relations with his wife. This right of the husband is the basis of the qualitative distinction between the sexual relations within a marriage and sexual relations between strangers. And it is this qualitative distinction that the marital rape exception seeks to recognize. In his view, the intelligible differentia also exists from the point of view of the victim, because in the case of non-consensual sexual intercourse with one's husband, there are no social ramifications whatsoever, because the forced intercourse is taking place within the privacy of the home, and more importantly, because both of the parties are married. Put simply, he argues that women are not similarly violated when they are forced to engage in sexual intercourse with their husband and with a stranger. Therefore, drawing on this unquestionable qualitative distinction between the sexual relations in a marriage and the sexual relations between strangers, Justice Shankar maintains that the distinction created by the marital rape exception does not fall foul of Article 14 of the Constitution, because this differentia has a rational nexus with the object of the exception to protect the institution of marriage and with the object of the provision on rape generally. Now, his reasoning is deeply problematic for the superficial manner in which it conceptualizes the right to sexual and decisional autonomy of women. Although he recognizes that the right is violated in cases of non-consensual sexual intercourse with strangers, he seems to imply that this right is subordinate and less valuable than the right of husbands to expect meaningful sexual intercourse. And in his entire discussion, he forgets and disassociates his articulation of marriage as an union of two equal partners when he fails to recognize that non-consensual sexual intercourse does not fall within the term meaningful sexual intercourse in itself. Throughout his complex yet superficial misogynist analysis, we can identify that in an indirect way, he seems to endorse the doctrine of implied consent, because he suggests that women have willingly and consciously chosen to be a part of a relationship of which sex is an integral part. Looking at his argument, we can understand how the right to privacy, when applied from within the framework of judicial misogyny and patriarchy, is robbed of its potential to advance gender justice even in the most minimal way. In doing so, we realize that even in the case of Puttaswamy itself, the Supreme Court had failed to recognize the context in which and the history from which critical feminists had criticized the traditional conception of a strict public-private divide. And through all of this, we seek to highlight how the right to privacy is rendered nugatory in social contexts that are structured around the seamless operation of the doctrine of implied consent. The doctrine of implied consent does not only deny women sexual agency within the marital bedroom, but it problematically extends to cover and justify the asymmetric assumption of domestic responsibilities, ranging from housework to reproductive labor involved in childbirth and child rearing, arising in context of the marital relationship, which is the source of this implied consent. Put differently, we can say that the responsibilities for unpaid housework and domestic labor are seen as an integral part of the sexual contract in marriage. And these together, they interlock and put women in a position of subordination and servitude. Therefore, in a sense, what we are saying is that the continued retention of the marital rape exception that indicates the normalization of domestic sexual violence, as it is interlocked with the performance of unpaid housework by wives, which is again legitimately expected as a part of the marriage contract. These are ideas that are both normalized and invisibilized in legislative and judicial imagination by the endorsement of the status quo. However, the endorsement of the status quo is not a morally innocuous or neutral position. Rather, it is an assertion that the claims of women to more just, inclusive, equitable, and dignified social arrangements are subordinate to the public morality of patriarchal orders. And these orders are constituted by unjustly appropriating the labor and sexual autonomy of wives. And thus we exhibit how the social norm of wifely submission to sexual wrongs within marriage and the irrelevance of consent in heteropatriarchal conjugality, they are the bedrock on which unpaid domestic and care work within the family rests and within which its devaluation is rooted. These dense interconnections, they trap women into what Miele refers to as heterosexual prisons. Put simply, we are conceptualizing this argument of the domestic work, domestic violence, and marital rape triad as a tool that we can use to unpack the possibilities for gender justice, both at the theoretical and practical levels. In order to fully grasp and understand the nuances of the structural violence that is inflicted on women by trapping them within particular social locations, and by requiring them to perform roles that are predetermined for them by an external structure. And in order to interpret the right to privacy and its attendant's right to dignity, liberty, autonomy, and equality in a progressive manner, we must resort to a contextual analysis of the rights of women and more broadly, trans queer persons. The advantages of such a contextual appreciation of the rights of women workers are highlighted by drawing upon the judgments of the South African Constitutional Court in the case of Sylvia Bongi Mahalangu, and by Justice Shakde's leading opinion in the case of RIT Foundation. In the case of Sylvia Bongi Mahalangu, the South African Constitutional Court presents a detailed historical account of the socio-legal position of domestic workers, most of whom are Black women who face intersectional discrimination on account of their race, their class, and their gender. This contextual analysis of the lived realities of domestic workers from their perspective enables the court to first identify the various ways in which the worker's right to dignity is infringed in the context of their work. And secondly, it helps the court to develop a non-essentializing idea of the identity of domestic workers, one that does not equate their identity with their experiences of suffering, but one that recognizes the multiple dimensions of their existence. Further, the court uses this contextual understanding to articulate the meaning of substantive equality as a constitutional goal that seeks to do away with the harms of intersectional discrimination in all its attendant dimensions. Now, this idea can then be extrapolated to achieve a more equitable distribution of the responsibility for housework between men and women and to recalibrate the worth of paid domestic and care labor. Similarly, Justice Shakde's nuanced interpretation of the context in which married women are called to exercise their right to sexual and decisional autonomy enables him, in the case of RIT Foundation, to first reject the operation of the doctrine of implied consent. He particularly says that the consent of women is required for each and every act of sexual intercourse within marriage, because only then we can fully respect the dignity, the humanity, and the integrity of the wife, who is an equal partner in marriage. This also enables him to recognize the impact of non-consensual sexual intercourse on a woman's right to sexual autonomy, bodily integrity, dignity, and choice to procreate or to refrain from procreating remains the same, irrespective of the identity of the offender. And thus, sexual assault, whether within marriage or whether outside marriage, it is equally injurious, degrading, and dehumanizing for women. Secondly, he uses this contextual appreciation to declare that marital privacy is subordinate to the inherent embodied right to privacy of the wife. He says that the notion of marital privacy cannot be invoked to keep the law at bay when the fundamental rights of the wife are at stake, because the law freely steps in to punish the wrongs that are short of rape, such as hurt, grievous hurt, so it cannot shirk off its responsibilities in the fact of a more serious infringement of women's rights. By thus viewing the right to sexual or decisional autonomy as a manifestation of the embodied right to privacy, which was identified by the Puttaswamy Code as a right that can be exercised across a variety of spaces without undue interference, we can extrapolate from Justice Shakde's reasoning to extend useful support to the claims of women who seek to exercise their decisional autonomy beyond the marital bedroom, to making choices within the marital household about the nature of the work they want to engage in, the time that they want to spend laboring outside of the house, and the time that they want to spend on personal recreational activities. Through these cases, and more generally, through the examples drawn in the earlier chapters of the book, we argue that in order to fully understand the emancipatory spirit and potential of transgressive actions, the grievances that it seeks to redress, and the nature of the rights claims made, we must adopt an inverse perspective of constitutional interpretation. This is what Guinar and Torres refer to as demosprudence. Demosprudence is an approach that takes its cue from popular movements and democratic conversations originating from below, particularly at the margins, to determine the scope and content of constitutional protections. Importantly, or phrased differently, what we are trying to say is that constitutional conversations need to be popularized and liberated from the citadel of only courts. Constitutional interpretation, rather, needs to be fostered amongst the citizenry in general in order to realize the ideals of constitutional morality through an exercise in dispersed sovereignty. In the final part of our book, we recognize that the scope of the right to privacy and its attendant rights can be curtailed not only by misogynist judicial interpretation, but by the limitations that can be placed on the right itself by the law. The validity of a law that seeks to curtail the right to privacy has to be judged in accordance with the proportionality standard, as per the opinion of the majority of the judges in the Puttaswamy case. However, all of the 6 judges who discuss the issue of the proportionality standard, they accord different meanings to its substantive tests and to the applicable evidential standards. In this right, scholars most importantly criticize the proportionality standard on account of its structural flexibility, which renders it a concept with no inherent meaning or no inbuilt restrictions on its meaning, scope, and efficacy to check on the validity of a rights restricting measure. Such a structural flexibility can be misused by judges to advance the code of public morality in the garb of legal niceties. This is possible because the judges can re-articulate both the substantive and evidential standards of the test, stipulated by the proportionality standard, to advance whimsical, subjective reasoning while paying lip service to the cause of gender justice. To guard against such an abuse of the proportionality standard, we argue that since what is at stake are the fundamental rights of cis women, trans, and queer workers, it is inappropriate to accord a high degree of judicial deference to the aims of the state, and that the state should be called upon to examine and to prove the necessity of the rights restricting measure by the highest standards of proof. Furthermore, since what is violated in the face of exploitative labor practices such as manual scavenging and unpaid domestic work is not only cis women, trans, queer persons' right to equal dignified treatment, but also simultaneously their right to access public places on equal terms without discrimination on the grounds of inter alia sex, the rights attendant upon the abolition of untouchability and the prohibition of forced labor. As these rights articulated in Articles 15, 17, and 23 of the Constitution are absolute, non-derogable, and all-encompassing in their scope, as they horizontally apply to private actors as well. Now, what this simultaneous infringement of these non-derogable fundamental rights of cis women, trans, and queer workers suggests is that the attack on their dignity, their liberty, their autonomy, and privacy in the face of exploitative labor practices is qualitatively different. It is more atrocious. And therefore, it deserves a higher level of protection by the courts, both in the performance of the balancing exercise of the proportionality standard and in their choice of the applicable evidential standards. Thus, by articulating the appropriate evidential standards that the courts must adopt in cases involving the fundamental rights of cis women, trans, and queer workers who are multiply marginalized, we also seek to close the loophole that arises from within the constitutional discourse. It is this, how we try to begin our arguments in opening up the fields of gendered bodies at work. And we would like to know more from our readers about their understanding of our approach and evaluation of its shortcomings.
Thank you. Thank you so much, Devi and Kalpana, for this wonderful introduction to your book. So I'll now hand over, I think, to Harini, because we've stopped with Devi, and then we can come back to Divya as a social scientist here. So over to you, Harini.
Yeah, hi. Thanks for the to setting up the discussion in the book, and it was an interesting book to read. What I found very interesting in the book, which is unique and was also important for a lawyer to kind of understand and look at, is how you've kind of drew from various other disciplines, like, caste studies, disability ideas, and like feminist ideas, to explain those complex nuances in such as the unpaid work and the paid work continuum, and also work in the public and the private space. Um, what I also found very interesting was the lessons that you had drawn from like movements and collectives to argue about like building solidarity between survivors and supporters, and how that is important, um, in the sense that survivors and supporters might be seeking the same thing, but it's also they're actually same but not different. But you kind of emphasize how it's important to consider the difference in what a survivor might seek and what the supporter might seek. So I thought that was very interesting to read about. Um, then coming to the whole idea of how Puttaswamy discusses dignity, and how you've drawn from that discussion to kind of see how it's actually manifested in a judgment like Navtej Johar, and how it can be further leveraged to in future litigations in labor, gender and labor, which and through these arguments I found that to be uh, very hopeful in this space. Uh, Especially the argument on dignity, and how you had referred to the South African judgment, which refers to dignity to be an inherent attribute, and how it attaches to an individual regardless of the work one person does, is important to make this articulation clear, because it sets out the context for the issues you discuss in this book, like work, like sex workers, bar dancing, unpaid work, domestic work, and manual scavenging. Um, when you refer to Puttaswamy to argue that the dignity is inalienable to the existence, however, like you also mentioned how this inalienability of something like of dignity is not something that is easily available for various communities within the particular gender. For example, the Dalit community, who in fact there's, even if it's uh, as per the Puttaswamy judgment, it's inherent attribute, but for the Dalit community and certain other marginalized community, it's like an everyday struggle to kind of to act to like to ask, or like even agitate, or even like emphasize that that's for this such dignity to be provided in respect to their work. Um, um, what I think is also uh, important is the way you had discussed about the invisibility and visibility of labor among the marginalized community, which also talks about like not only recognizing labor, but also the not only making labor visible, but also the person doing the labor also visible, which I feel it was an interesting takeaway to kind of look at. Um, Before moving on to my thoughts on the unpaid work discussion, I liked how you had kind of set out, I think, Professor Sandra Friedman's discussion on substantive equality, like, and how, like, the different stages, like, for example, the recognition part, the redistribution part, and participation, all these discussions, and how they kind of manifest in different within the different communities. Like, for example, in the transgender community, they had their dignity was in a way kind of recognized by the Nalsa judgment, when the judgment spoke about self-determination. But somehow that recognition was kind of diluted when the act came up. And also, like, in a place you had mentioned how the transgender community do not kind of are not able to agitate like certain important exploitative, they're not able to kind of seek remedy for some exploitative purposes. For example, if there's sexual harassment, they're not covered under the Sexual Harassment Act and the other kind and the other acts. So it in a way it kind of helps to see how even when recognition is provided, there is a dilution through these enactments and through these judicial pronouncements, which kind of again takes you back to the question of whether these dilutions even take into consideration that dignity which the court in the first instance sought to give them by actually articulating that their gender is self-determined. So it was an interesting place to kind of see how there are like within the different communities, the marginalized communities that you discuss and the different kind of works you discuss in the book, to see how like everyone's place in a different position when it comes to substantial equality as defined by Sandra Friedman, and how like transgender community, even if they are kind of their dignity is recognized, it's still getting diluted. So when like keeping this in mind, when I think about the unpaid work that you had discussed in the book, you had referred to the Motor Vehicles Act and how unpaid labor of housewife was valued when the court kind of calculates the nominal income when the housewife gets injured or permanently disabled or even passes away. So it is a welcome step. It's a way, again, back to how courts are trying to, recognize the inherent dignity in the work done by a housewife. But at the same time, this dignity, like Devi also mentioned in a note now, that this dignity is again kind of diluted when you think about it from the angle of this articulation comes up only when a case of crisis, like only when there's a death or only when there's a permanent disability. And this again gets more diluted when you look at the ways in which the unpaid labor is invisibilized, like how you had mentioned in your article in your book about how in the census the women who do unpaid work are kind of categorized as the same as a beggar or a prisoner because they do not bring in productive work as per the state's idea of productive work. So this again and dilutes the leeway you get in a Motor Vehicles Act where unpaid work is kind of recognized. This saying that it's work which is important and which is necessary for nation building, but at the same time it's against the dignity argument here kind of gets diluted when it's invisibilized in other aspects of it, which I also kind of think is very important to look at, because not only if the dilution comes from not only these like acts or schemes, like you also mentioned something about the dilution through the Swachh Bharat Abhiyan on the on the dignity afforded to the manual scavengers. Like what I'm trying to articulate here is that these every place there's some kind of recognition or some kind of dignity for the unpaid work which is given, but at the same time it keeps getting diluted through like different like statutes or schemes or even through judicial pronouncement. This judicial pronouncement I feel is something which needs a little bit more discussion, because as we see there are judges in courts, there are there's so many different factors which kind of assess like how a particular judge might view an issue such as unpaid labor done by women. You had actually pointed it out in that 498 case of Justice Vibha Kankanwadi, who had spoken about it, and you had made a mention of that judgment, how she understands unpaid labor done by women. She kind of articulates it in a way that it's within the marital relation, and it's a normal expectation within a marital relationship to perform these by the women, for the women to perform such acts. This I feel is somewhere very important to kind of understand, because even like from the cases that I'm aware of, like in like a maintenance case, for example, when you look at how courts kind of assess maintenance, and when they look at the maintenance that needs to be provided to a housewife, courts are adjudicating issues which are far from the reality, like how Justice Baba Vibha Khamkanwadi talks about, like this is expected in a marital relationship. The ways in courts kind of articulated in like maintenance petitions are also more, crude or more crass, I would say. But what I'm trying to understand is that these dilutions, and what is like how there's for example, there's some kind of recognition which keeps getting diluted through various other ways, whether these recognitions are actually kind of which makes me these dilutions actually makes me question whether the recognition was actually provided by recognizing the dignity, like were they actually based out of providing them, or understanding the way dignity was understood by the South African court, or whether it's more of an opportunistic way of kind of deciding whether a housewife who is doing unpaid work needs to be paid compensation. So what this kind of again brings me back to the question is how do we bring these conversations to everyday court, this how do you bring these conversations into a courtroom? One suggestion or one argument that you had made is also in reference to the South African judgment about how bringing in these contextual things before the courts would kind of give them the understanding which they lack. But at the same time, I'm also trying to wonder how does one kind of bring in these complexities or bring in these difficult conversation which happen beyond the courtroom to courts, because end of the day, when the judges are making like these judgments, and when they are writing about these issues which are very sensitive, there could be various reasons for them to not kind of pay attention to such issues. Like it could also be a more routine way of for them to look at a case and then dismiss it because of the enormous number of cases before them, or they lack awareness or lack sensitivity. No, we don't know, but there's so many different reasons. But like this bottom up approach which you had kind of mentioned about bringing together the citizens, bringing the constitutional arguments and all these conversations from the bottom up approach, rather than actually articulating it in court, makes me wonder what would be an alternative. In the sense, end of the day, these constitutional arguments are not made in an everyday court. It's not made in, like, for example, a family court for that matter, when matters are asked, or even for a motor vehicles tribunal. So is it important to bring in these lived in experiences of women, what they face through these conversations in court, or through these arguments a lawyer should make in court, or or for example, how courts kind of understand, how do you kind of make the courts understand that what they understand is far away, and it's all the understanding and conversations on from the gender and the labor studies gets undercut by these judicial thinkings and judicial thoughts by these judges. So how does one kind of address that issue? That's what left me like after reading, I felt that's one thing which I thought I should like address. But apart from that, I felt that the book was an interesting read, and it gave me it makes a lawyer think beyond the letter of law. It helps in setting the context for litigation, and to ensure that these contexts are not lost in the court because of the court's reductionist view on such matters. I also feel that the book provides a critical insight on gender and labor that not only paves way for future research, but also for courts to frame questions for adjudication that would address claims of the most marginalized, which I feel is very important because somehow these framing of questions in these everyday litigation kind of gets lost and all the conversations get left out of the courtroom. Yeah.
Okay, thank you so much, Harini. Thanks a lot. That was really wonderful. Thanks. So now moving on to Divya.
Okay, my observations are going to be much shorter, but I just wanted to say that I absolutely enjoyed reading this book, and I've shared this already with the authors of the book. I'm going to have my reflections in two parts. One is to think about how this book is really interesting for teaching, especially in a multidisciplinary environment or in the social sciences. And the second would be about its role, in thinking about research in the social sciences. But before that, I'll just start with a quick incident that occurred yesterday. So my son came home with a consent form that I had to sign, which now says there is going to be one student, one unique ID. And the school, of course, said it's not mandatory. It's voluntary, but we all know there is perhaps no choice in that matter. And the first thing I found myself doing was, looking for information on this, and the Puttaswamy judgment appeared right on top because it was about the right to privacy. And I really do thank the authors, because I remember when the judgment came out many years ago, I heard about it and it was a passing moment, and I don't think I thought about it a second time. But thanks to this book, I have thought about it so many times and how central it is to many other aspects we sort of engage with, and I wouldn't have done it this carefully otherwise. So to say that many aspects of this book have stayed with me beyond sort of what its purpose is, perhaps. I must also confess by beginning that this was not an easy read for me, because as a social scientist, legal language can seem very overwhelming. And by no means is this a judgment on the writers, their style of writing. And I've already shared this with the writers before, that it is sort of a shortcoming of our training in social sciences also, where we barely get an opportunity to engage with the law or any kind of legal frameworks, even if we actually have very close interaction with it in our everyday life. I read the book more than once because I was going to teach it in class, and I thought it was a very bold move that I was making to take a legal text to the classroom. I just wanted to quickly reflect about what this book can do for people who are in the social sciences and want to talk about gender within the classroom. I think for many of us, who are about my age or slightly older, when we talk about gender, a lot of our training happened in women's studies departments, in the 90s and the 2000s. And I find myself always in a very strange situation to go into a classroom and start talking about gender, which is really about women's work, which is really about women's bodies and really about the women's movement, right? And increasingly, we are at a time, moment in history where we can't do that in the classroom, because there's, of course, more gender diversity in the classroom, but also this vocabulary that is constantly changing. And I truly appreciate this book because it allowed me to connect gender in labor. And when I say gender, I mean more than women's studies in this aspect, right? Because you started thinking of it, it allows you to start thinking about gender as something outside of the non-binary framework and its relationship to work. And I think that also is a really interesting challenge that we social scientists are trying to crack through, because when we talk about data, very often the reason we don't talk about trans or queer workers is because there is no data. But as the book also sort of talks about how our the bureaucracy, the government, the courts are also not without gender. They're deeply gendered in the way they sort of think about various aspects of society. The lack of data is also perhaps an outcome of one of these very gendered notions of how we operate in society. And so, in the past, perhaps I would be very careful of how I went into a classroom and taught, for example, gender in the city or gender in work, where anything beyond women's work would then become anecdotal information, but not so much data, because there was none. I think what I really found useful in this book was to find these very concrete examples from different parts of the world, where I could now talk about work and gender through these various examples that were, that were actually in action in different parts of the world. I also wanted to say that what it allowed me to do in the classroom was to think about the reading down of Section 377. And then connected to the right to privacy, but also connected to work in ways that we haven't had the opportunity to do before. So for me, that was really a very interesting point in the way sort of the book, opened up many different conversations in the classroom. In terms of research, a lot of my work is on informal work. I look at paid and unpaid work and the nature and conditions in which women work, and how does that impact their time use, their health, and so on. Interestingly, my interaction with the legal framework so far has been the labor codes. That is the extent to which we sort of, look up legal language, or what does it say about how people, what are the frameworks that sort of govern people's work. But to think of dignity and privacy as sort of reference points to work is something that I think this really does open up for labor scholars, those who are trained in social sciences, because these are not natural extensions that we push ourselves to think about. So for me, both the concept of sort of dignity and thinking about privacy within the work was really useful. I remember this question, this example we were discussing in class, where we're talking about, the metro, a city in Kerala hired a lot of trans women to work in the metro, and eventually a lot of them left because they couldn't find homes in the city. So the question in the classroom was also, whose responsibility is it to ensure dignity in work, at the workplace, and just in society, and the way we sort of function in society. And I think that to me was a question that we grappled with quite a bit in the book. It sort of lays out this framework for all the ways in which we think about gender. And if the authors ever consider a second sort of continuation to this book, I do hope you will also tell us some pathways, because I think for many of us, this was the first sort of entry into thinking about it legally. But what does it mean in terms of non-discrimination, and what are the pathways for sort of enabling more people into the labor force? And I was also sort of interested in the ways in which the book uses these various frameworks, talk about invisibility, marginality, transgressions, emotions, and resistance. I think really interesting mix of different ways of thinking about labor and gender. Another phrase that really opened up several conversations for us was the phrase entanglement of marginalities, because simultaneously we were also reading Annihilation of Caste by Dr. Ambedkar. And, so it is a very interesting sort of step up from graded inequalities, because it allows us to think about gender and caste as also being things that are inseparable in certain kinds of labor markets. And we know that the relationship between caste and, gender is sort of very tight in certain kinds of workspaces, but also to think about domestic violence within the household, but also outside, especially when the public and the private are not very clear, and it is so blurred in certain sectors of work. And there is also a phrase, there's also a couple of sentences in the book where you talk about, the assumption that male productive work takes place in the public, and a lot of women's engagement with reproductive work takes place in the private. My own research in the past few years has shown how reproductive work continues to occur both in public and private. So women carry their children to work. The reproductive work never sort of ceases to exist. But the productive work is also very undervalued. So it's not just reproductive work that's undervalued or not paid for, but productive work itself being deeply undervalued because of a certain feminization of a particular sector of work or the labor force. A lot of my work is in the construction sector, and it's really been a very curious case for me, because when we look at, say, domestic work or sex work or care work, we talk about feminization of the labor force and how women don't get paid enough. But here is a masculine industry globally where women barely work in the construction sector. We have a fairly big population of women who work in the construction sector, and yet wages are very low. So it's not a feminized labor force, it is a masculine labor force, and yet the wages are really low. And what is that, the word dignity then really holds a very interesting entry point for me to explore it beyond the word precarity, which is the favorite word for a lot of social scientists. And I think we use precarity quite loosely today. It can be precarity in your workplace, to housing, to, it's become sort of the pet word for a lot of our research. But to think about dignity and its relationship to the legal discourse, I think is a really interesting way to explore how work itself is imagined both in the public and the private sphere. And the other thing I wanted to sort of quickly talk about is, how I think one of the things that I kept looking for in the book, and I think I found pieces here and there, was to um, look for signs of what does dignity mean in the long term in a human's life cycle, for example. So, for example, the occupational health safety guidelines, for those of us who do labor studies, are familiar with OSH and where accident or injury is compensated for. But a lot of work that women do is slow erasure of the body. It is not something you will wake up tomorrow and find there's a finger gone missing, like in the industrial accidents. But something that's like a very slow erasure of the body, where over a period of time, exhaustion, stress, back issues, all of this because of the nature of the work. And I think that to me also was a very interesting question of dignity of body, dignity of self, dignity of your right to a safe work environment. And that's something that I was sort of trying to connect back to the text and see if we are able to move beyond legal frameworks that are just about labor codes, but also to think about constitutional law and criminal law, which I personally haven't engaged with before. But I think the book just gave me a very interesting new perspective to think about how, perhaps these are other places where a researcher like me could start looking for evidence or looking for, cases and data that is absent from our regular data when we talk about labor. I'll stop there, but just before I go, the very interesting thing, I would definitely encourage everybody to go through the footnotes or the endnotes of the book, because I think a lot of history of the feminist movement is captured in the notes that come with the book. So I remember having to sit with my laptop as I was reading the book to also, on time go and check what do each of these endnotes actually mean. And that could make for and I was telling this to Prabha yesterday, for those of us to whom feminist rights have been, the feminist movement has handed over a platter of excellent things to people like me on a platter. We haven't had to fight for many things that, a generation before has fought. And so the endnotes and the footnotes are a really rich repository of that information for those of us who want to look up the history of how did we arrive where we are today, and perhaps the direction in which we could move forward from here. I'll stop there. Thank you.
Thank you so much, Divya. That was really great. Everyone's been very patient, so I want to invite any thoughts from the audience. And maybe while people formulate their questions, Kalpana and Devi, did you want to respond to anything that the readers have shared with you?
Devi? Okay, just very quickly, thank you both for these for your comments. I think in a very important sense, both your comments taken together go into the heart of what we were trying to grapple with and what we were trying to do. Harini's comment on how should courts be made to understand. My problem, and this is something that Devi and I have constantly agonized about when we were looking at particular cases, was why are these learned spaces which are meant to deliberate on questions of justice so completely illiterate about rights? And that really is a major problem. What you will also find is that you can't actually say that one judge is consistent across different judgments in their nuanced understanding of the Constitution. Forget about special laws, just the Constitution. In a nuanced understanding of the Constitution, between one case and another, you don't actually find a consistency by the same judge. So basically, that is the lay of the land. So how do we actually make an impact? Honestly, I don't know. My only response is that in engaging in writing, in engaging in debating on the reach and the scope of the Constitution, on questions of justice in a very nuanced, layered way, we can hope that these arguments will be picked up at some point by some judge. Yeah, but we still have to hope that they will be picked up. It's not a guarantee. There are a few judges across different courts who will actually use our own intellectual histories. You know, Periyar, if you look at Justice Chandru's judgments, for instance, he will begin with Periyar, go through Ambedkar, go through the Dravidian movement, go through what we understand by the term jurisprudence in arriving at a particular judgment in a particular case. No? But you do need judges to be able to open out and to be willing to open out. You don't have them opening out very easily because it is a gated community. So
I would just like to,
yeah.
I would just like to add two more points. You know, like you pointed out that the reluctance of judges to discuss these complex issues of gender within the precincts of the courtroom. Harini pointed out that, you know, they fail to engage in these issues because of different reasons, such as lack of time or lack of awareness, things like that. But these are all structural deficiencies that reflect new domains in which the socio-patriarchal norms are operating in our society. You know, it is, in a way, we are saying our judiciary is not structured to address your concerns. Here we can, and in our book, we do draw upon the ideas of Sandra Friedman to conceptualize the role of courts in advancing the idea of deliberative democracy. When she says that courts should not engage in decision making based on the ideas of power, but rather are based on the power to convince. And the power to convince would ensure an equality in participation where even marginalized groups can come in, voice their concerns. And if their arguments are cogent, they can be accepted as a part of the constitutional doctrine of the land. So what actually is required is a retraining of judges to sort of, you know, teach them what their role should be. You know, it is not merely deciding cases in a routine manner, but also to understand that their decisions fit within a larger conversation that is not restricted to the legal domain, but, you know, it merges with the social fields, so to say. And judges, you know, like we say, law should not only be a reflection of social change, but it also should try to change the society in ways when, you know, like, because constitutional precepts are above social norms and they're there for a reason. So we need to value them appropriately, both by the way in which our governmental structures are constructed and in the training that is imparted to judges.
Yeah, and very quickly on Divya's comments, I'm really very glad to note that you are able to use this book in a classroom, because that really is the ultimate. You know, I mean, if it doesn't have all the answers, like I said right at the beginning of my opening comments, it doesn't have answers. It is not exhaustive. It's not meant to be exhaustive. It is meant to be something that will trigger thinking in a different direction. And our hope is that not that we will write a second book, but that somebody will pick this up and take this forward. There are gaps and there are questions. I think it raises more questions than has answers. But if it is, if it is something that triggers a conversation and that sustains a conversation in a different direction, I think its purpose is achieved. So, really, thank you for that, for taking it to class and for telling us about it. If I were to actually work on this at this time, if we were to work on this at this time, one of the works that I would certainly put at the center of it is Vaibhav Sarya's Hijra's Lovers, Brothers. Because I think that the way in which Sarya complicates our understanding of gender is really quite stunning. And it would, as I was reading it, I felt that, it breaks the monotone of the binary, of having to look at women's cases in order to extrapolate there into the sphere of queer workers or trans workers. It helps us to just break out of that mold. So I would actually add that to,
Great. Thank you so much. I think I saw a hand go up. Was it Mihir? Did you have a question? Please go ahead.
Hi, yes. It was just sort of, I had the opportunity to read the book and review it earlier this year, and it was an amazing book and sort of echo everything about opening up an amazing new field. I just had two quick questions, which were, my background is sort of doing PhD in sort of queer identity and the law, and that's where my questions come from, I guess. And it's, the first one was connected to the conversation related to Harini's comments about how courts can sort of understand all of these new ideas which are able to come up in sort of community movements and things like that. And I was thinking about the recent queer marriage litigation that happened. And what we saw a lot was, it's not just about the courts understanding or not understanding, it's also about what we present to the courts. And all of the amazing sort of work on the heterosexual marriage and the possibilities of queer marriage presenting some new alternative futures. A lot of that was completely lost when we actually went to court, because the community wasn't able to bring all of that rich debate to the court itself. It sort of had to whittle down the more respectable arguments, the ones that were more like the heterosexual institution of marriage, which you sort of have critiqued in your book. So I found that quite interesting. Sort of an example to show that it's not just about the courts, even the movements have to find their way to the court in the first place. And the second sort of question or sort of comment for response was related to the chapter, I think the fourth chapter on the analysis of the Trans Act and sort of gender as a ground in Article 15. And was very, very good engagement, very new engagement, which not many people are doing yet. But I did have one sort of provocation, which is that one of the arguments was that the Trans Act sort of presents a sort of separate but equal kind of picture, that it's sort of separating the trans question from the other women question, the gender question. And while I definitely see that argument, I was also thinking about what's happening right now in Tamil Nadu, where so the trans community there is actually protesting against the government creating an LGBT policy which includes trans people. So there, trans people are actually wanting to separate themselves from the queer movement on one side and the women's movement on the other side, and find their own path, their own policy, their own sort of institutional structure to deal with their issues. And of course, there's a lot of real politics going on there. There's a lot of institutional dynamics going on there. But it's something to think about when, we ask for more solidarities, for more common ground, whether the movement itself wants something different. Thanks.
Yes, please, you can respond. Thanks.
Yeah, I think just, both of these concerns, they raise one issue, and it is about the terms on which the concerns of marginalized people are included within the majoritarian discourse, you know. So what is important is not only including their concerns, but the manner in which they're included. And pertinently, you know, this involves, like we've identified in the first chapter itself, it involves a question of, just let me pull out the extract for. Yeah, we have to ask not only what the subject is being included, but we also have to ask what of the subject is being included. What of the subject is being incorporated inside the structure, and what of the subject is being left behind. What, in making this argument, what we seem to suggest is that you know, true emancipation is not only possible by incorporating different identities within the majoritarian discourse, but also by creating a platform whereby they can define the language and the terms of the discourse and the manner in which they're included, so as to fundamentally dislodge the structural premise on which our society is structured. You know, so if you're including trans or queer persons in a society that is structured by you know, heteropatriarchal norms, then their concerns would only be understood in a superficial manner. You can never understand their concerns truly until you modify the entire society so as to welcome their diversity in ways that are important. And these ways of difference should be actually pointed out by the community themselves. This is where, you know, we rely on bell hooks to say that margins are not a site that we should move out of, but they're sites that we must consciously cling on to because they nourish our ability to offer resistance, and they remind us of what we need to bring from the outside to the discourses in the mainstream. So this is one way in which we can look at how or the terms on which movements need to be incorporated within our judicial discourse.
Also, to add to that, Mihir, I think the problem is in not or rather in expecting that the either the trans community or the gay community or the bisexual community will be agreeable to be grouped into a catch-all category in order to be governed. No, so the question that we raise about the separate spheres and the problem with the separate spheres argument is that even if the community seeks a distinctive space, like women earlier, you're talking about a different space. You're talking about reservations. You're talking about creating dedicated spaces that are separate. But when you talk about creating separate spaces, does that mean that you are actually asking to be excluded from the general overarching protections of legislations that are offered to all, irrespective of identity? Yeah. So the point is that the creation of a separate space cannot automatically, should never involve the removal of existing protections from a more general umbrella of protections, because that then creates the opportunity for the separate space to be diminished in status vis-a-vis the rest. So of course, any community, any particular community can actually ask for a distinctive space and to be recognized as an independent, autonomous entity. And that should be granted. But in that recognition as an independent and autonomous entity, how do we then ensure that the overarching rights and the overarching access to questions of justice remains, for groups that are distinctive, remains in the general sphere as well. It can't be that you remove it can't be that you remove a particular group from general protections in order to grant them special protections. The special protections must always come alongside, in addition to, over and above the general protections. And also whether communities or groups actually advance arguments with nuance, advance arguments, taking intellectual histories along with them, is a very fraught question, because we have that in a lot of litigation concerning women's rights as well, that you don't necessarily go with the ways in which the question of women's rights has developed and gathered complexity over the years. You tend to kind of be reductionist in litigation, and that's also a problem that several of us have actually reflected on in concrete instances when cases go to court. But I think that is really something that calls for calls for longer and deeper work within movements as well.
Anyone else has questions or reflections? I think I just wanted to ask one small question, which was really about the marital rape exception, which Indra Jaisingh has recently argued that actually does not exist in the books by way of a creative interpretation of the Constitution. So I just wondered, what is our sort of our affect towards what seems to be a losing game? One is either that the Constitution already provides for a step further than we think we are, or one of frustrations with the lack of social movements and the receding spaces for them to, enter courtrooms, and some form of maybe what we've identified in governance feminism as a way of engaging with power, which is about finding, influencing state spaces in a more conventional rather than oppositional sense. So I just wondered if you had any thoughts on Indra Jaisingh's argument in that respect, or more generally about the prospects for, especially in the arena of gendered labor, where I think we find, the kinds of spaces one had. I mean, there are, for every movement that's willing to go to court, there are many others that have disavowed any engagement with courts for good reasons. So I'm just curious about what you think about that.
Well, I think all of us kind of went through a phase when we thought it was productive to work with legislators, to try and advance women's rights through progressive legislation. Yeah, I mean, and the domestic violence, the Protection of Women Against Domestic Violence Act is a classic example of that. But I think the problem with the marital rape exception is that both courts and legislatures don't see it as a question that is embedded in Article 21. It is reduced to a consideration of the rape provisions in criminal law, or the rights of of men in marriage, yeah, whatever the case may be, one way or the other, but not centrally to do with Article 21 rights. And I think that part of the problem really comes there, so that even courts' treatment of the exception tends to be piecemeal. So the court is willing, for instance, to say that marital rape is unlawful in the case of minors, but we are not making a comment on intercourse between adults. Yeah, so a classic case of jurisprudential dissociation, that it doesn't concern us. And the question that immediately arises before us is, if you are a constitutional court and you are actually finding that non-consensual intercourse is bad in law under the Constitution for one age cohort, how can you then exempt another age cohort from the same protection? In fact, the protection that you give to minors would automatically, by your very reasoning, extend to all women in marriage. Yeah. So I think it has to do with a fairly poor, deficient understanding of the Constitution. And if that is the case with courts, it's in fact worse with the legislatures, particularly in our current moment. Yeah. So I don't see that there's really a possibility of working with. We can only work against for now. Maybe that will change in the future. I don't know.
Thank you. Any other final thoughts? If not, I think we will conclude on that call to action, which is to engage in resistance, practices of resistance. So thank you so much for this wonderful gift of a book. And I also look forward to testing it out with law students and and will be definitely sure to share what they think, because I think it's much needed, this kind of call to think more creatively about the law. So,
and your work was in our book, so we were really happy when you called us, because we said us in the book.
No, pleasure is all ours. Thank you so much, Kalpana and Devi. Thanks a lot, and Harini and Divya.
Thank you, Harini. Wonderful. Thank you.
Yeah, thank you so much.
Thank you for having us. And for engaging in the first in-depth discussion of our book. It helps us really feel like, after we'd written it had been a year, but we could not see the impact that it was having. But today, to see so many people being engaged with it, and even if it is succeeding in raising the right questions, I think we've done it right rather than providing solutions. So. Yeah,
and I think we've hit December. Otherwise, I was definitely sure there'd be more people. I think it's the December fatigue, but worry not. It's been recorded, and we will trim it with just the right parts, and we'll share the link so that I think we can share this more broadly. I think it's a conversation that everyone needs to listen to and importantly engage with the book. So thank you very much.
Thank you very much.
Thank you. Thank you.